We have a preliminary matter, Your Honor, that I think affects the proceeding.
Okay.
Yesterday, Judge Nakamura announced orally his ruling that the granting of the sublease was not valid because they denied the request for a contested case. So the proceeding was that there was a sublease under consideration, a contested case was asked for, the contested case was denied, and therefore there was an appeal to the court, and the court said that the denial of the contested case was an error. So the sublease consent by BLNR is now invalid. That affects the sublease itself because it's required to have BLNR consent for there to be an active sublease.
Okay. Do you have the written order?
I'd
like to see it.
We don't have it yet. It hasn't come out yet that we know. What we have provided is 2 exhibits that just discuss what happened. Those exhibits are newspaper reports. That was the source of our information.
Okay. I have to work off a written order because I need to see what he ordered.
And I thought you might feel that way.
Good.
So in my motion, I said alternatively that maybe we need to stay this proceeding because, well, our argument is that TIO, the basis for their intervening was the fact that they had obligations and rights under a contract, and the contract they referred to was the sublease. If that sublease is no longer valid, then their whole reason for being here is no longer valid.
I'm not
So
going to pre-rule, but I will comment on that after I hear from everybody else.
Okay.
All
Well,
right.
our position is that they are now disqualified to be an intervener and should be dismissed. Alternatively, it may need some more information before such a decision could be reached, such as seeing the written order or briefing the question or whatever.
Exactly.
But the issue is now on the table as to whether we as parties should be obligated to cross-examine and prepare for cross-examination of witnesses from a party that may no longer be a party. So alternatively, we're asking for a stay of the proceedings.
I don't have a problem with making a ruling on who's a party. That, I think, is my jurisdiction. But as far as anything else, I don't think this hearing focuses on the sublease or the granting thereof or the denial thereof. It focuses on the application for the CDUA. So that's what I'm thinking off the top of my head.
I understand. But if the basis for a party being in this proceeding is that there is a sublease, and if there is no longer a sublease,
Okay,
then the basis is gone.
I heard you, so now you're
Okay.
repeating yourself.
Oh, I don't want to do
But
that.
let me go back to this.
Yes.
I was very careful when I admitted the parties to say the basis of the admission. Now, whatever the arguments may have been for their admission or against their admission, in my ruling, it's in a minute order. In my ruling, I'm sure that I put the basis for each one, and I did it very intentionally. So please go back to that, and we'll take a look at it.
Okay.
All right, Mr. Ng?
On this motion that was just filed today that we haven't really had a chance to look at, is out of order. So we're happy to prepare a response to the motion. It'll be in opposition. I will note that Minute Order 13, which is the minute order that allowed intervention from numerous parties,
That's the one I'm referring to.
admitted TIO on the basis of a substantial interest, not on the basis of a property interest. Nevertheless, we still have a property interest. Thank you.
And I think I was careful because my recollection is not only did I admit TIO on the basis of a substantial interest, but I also admitted them on the second criteria, which is assistance to the decision maker. And that's how everyone else came in.
That's correct, Your
All
Honor.
right, thank you. Mr. Kayama?
Yes, good morning, Your Honor. Couple of things. With respect to this new issue that was just decided by Judge Nakamura, the filing of Mr. Simpkins' motion.
Do you have an order?
Well, that's what I'm getting to. My point is that I think it makes sense at this point to stay these proceedings until that minute order comes in, until the other side has an opportunity to file their opposition, until we've had an opportunity, if the court needs, to brief the issue as well. So
I don't even see how it's connected to us.
Okay.
As far as the focus of this hearing. But nonetheless, I'm not going to waste time this morning. Let's take a look at the written order when it comes. I imagine it'll be briefed by way of submissions to the documents library, and we'll deal with it then.
Well, the problem is, Your Honor, it goes to, again, the standing of the TIO. If the TIO no longer has standing, then the calling of these witnesses would also be out of order. And that's why the request for a stay of these proceedings until that order
Your
comes in.
request is denied. We don't even have a written order, so let's not waste any more time, please.
Right, but I also need to make for the record, Your Honor, and just for the record, is that two things. One, TIO never, in their application, requested that they be permitted pursuant to the minute order that was granted by their court. Their argument for being admitted as an intervener rests solely on their contract and their sublease and their property interest. So I understand that the court did, and I'm not exactly sure how the court also added them as providing some substantial assistance, but if I may also make this for the record, we do know, as opposed to the other parties that were allowed in, is that they have a Hawaii or local connection. TIO does not.
Thank you.
They are a Delaware corporation or a
Thank you, Mr.
nonprofit.
Kayama.
Okay, Your Honor, I still need to make my record about
Then
the
make it
appearance.
succinctly, because there are 4 other people in line behind you.
Okay, but the appearance of independence, Your Honor, of the hearings officer, I know that the hearings officer, and I'm not certain that the hearings officer wrote the minute order by herself or
Then
without
let me
counsel.
cure you of that curiosity, because I did write that minute order. I put it together, and it reflects the oral ruling I made. So someone else was here in your stead at that time. You can check the record.
Okay, and my record, Your Honor, respectfully is that, of course, the hearings officer does obtain counsel and advice from the Attorney General's office, and we do know that as a result of this ruling by Judge Nakamura, I think the court, at least the hearings officer, needs to reassess that question which arises about the appearance of independence. Well, you're cutting me off, so I'm trying to make things short. I have a better explanation if the court, if Your Honor wishes.
I need to see it in writing.
Okay,
Thank you.
thank you.
Mr. Ching?
Clarence Cheng. I'd like to second Mr. Kayama's remarks, and I'd also like to observe that if indeed the basis for the admittance of TIO as a party is based on these documents, especially the sublease agreement, that their rights at this point are no more or no better than that of the public. I would like to move to join Mr. Simpkins' motion. Thank you.
I look forward to your written joinder. Thank you.
Did you know this was going to happen?
I don't understand.
Did you know that the police was going to be not made, so you intentionally made sure that they could be part of our contested case hearing?
I did not say that.
I heard. Did you write it down? Okay, thank you. We have it on TV.
Ms. Aluli?
Your Honor, I'm making a special appearance for Mr. Flores, unfortunately, because he's not able to be here today. Unfortunately, he sent me a verbatim transcript. I know Ms. Chino was present in court yesterday with Judge Nakamura, and basically, we were told that the consent is void, the sublease was invalidated, the remand is invalidated, and a contested case hearing needs to be held for the consent for the sublease. And specific reference was made to Section 4 of Justice Pollock's concurring opinion. Your Honor, I did take a look at that opinion and the reliance on Judge Nakamura, and I would say that there was quite a bit of discussion about the property interests of the Native Hawaiian cultural practitioners being a property interest, and that in light of it being a constitutionally mandated property interest in public lands, that it could not be deprived, they could not be deprived of that without a full, fair, independent, open hearing and repeatedly foresight planning was iterated in Justice Pollock's concurring opinion. What makes it difficult in this situation is we have a witness who is going to be testifying on property law, which is ultimately for the finder of law and fact yourself. So the question of whether it's proper in terms of an expert witness is debatable. And secondly, this TIO has been deprived by virtue of the withdrawal of consent by the judge's order. I realize it hasn't been reduced to writing and it's not effective until written, but it was, I suppose he should just issue it was based on a motion by the DLNR to either stay those contested case hearing for the sublease or for Judge Nakamura to rule. So he ruled. And it wasn't that Mr. Flores came in, he's just doing what he thought he was supposed to be doing, but it was the DLNR that made that motion. So
Okay.
we're all standing here today wondering whether, and the other thing about it is Section 4 of that concurring opinion speaks to the point that there is no way to reverse or cancel a permit once issued. And that is on page 40 of that concurring opinion, that there is no BLNR rule which provides a procedural vehicle to reverse a grant of a permit. So we're here kind of going, well, where is the cart and where is the horse? Which is Judge Nakamura's concern. And does the sublease come before the permit? And that is a dilemma that I think this hearing officer is going to have to confront, because there's nothing coming from the applicant other than this
The
chaos.
applicant for what?
For the CDUA is the University of Hawaii, you know, and there again in the concurring opinion, Justice Pollack goes, it should not be who applies for the permit who's running the show. It is an affirmative duty on the part of the DLNR to make sure that the only property interest we know of at this point is that of Mr. Flores and the cultural practitioners.
Okay,
Okay.
I think we're mixing apples and oranges, but I don't know enough to say it. And it sounds to me from what you're saying to me that if someone requests a contested case hearing, that they're entitled to two, that there's a contested case hearing requirement for the permit application for the sublease, as well as for the CDUA application. We're doing the CDUA application right now. I do not know how the two cross over. So I need to see this briefed. I think we're wasting time right now. I do not intend to stay today's proceeding. I can't. I don't even have the written order.
I understand, Your Honor. And I will try and get a hold of NHLC counsel to see if they can get the judge to issue a minute order so that
The minute order is not going to do it for something this big. He needs to issue an order.
It's going to take a while because
Well-
they have to settle it with the DLNR.
I think you understand where I'm
Yes.
coming from.
What I
Thank you.
don't want to see is that this process.
It shouldn't impede the process. It sounds like what you're telling, based on what you're telling me, not knowing more, that they're two separate processes. There's a process for sublease permit and a process for CDUA application. And we're in the CDUA application. And I heard what you said about, I think you're talking about Professor Callies and the property person who's going to be testifying. If what you're saying is correct and what I'm reading is correct from you, then there would be another contested case hearing for the permit application, at which time there would be witnesses, perhaps Professor Callies again, and that's where all those other questions would go. So I'm sorry, but right now, I just don't have anything more.
But there's no applicant. TMT is not the
The
beneficiary.
university is the applicant for this process that we have undertaken. I have clearly stated my reasons for the admission of TIO as a as a party, just like I did with all the other parties. So I don't see that as contrary, but I cannot rule on this today, and we're going forward. Thank you. Ms. Peixoto?
Aloha.
Aloha.
I understand that, I just have a couple things to say.
Okay.
I understand that, I'd like to say that I would add my name, Mauna Kea Idaho, in support of the two motions before you today.
There are no motions before me.
Oh, okay. Well, they are, anyways, Lanny Sinkin and Hank Fergestrom filed something. But I also want to say that I hear you saying you want us to brief it.
No. Let me be clear. I don't have a written order, so if they filed something based on some kind of order, it has to be written. I need to see that.
Oh, I
And
see.
then the motions would be filed based on that order, so then we all know what it is, and then those things would be briefed. Nobody has to brief anything right now. We have nothing
Okay.
to talk about.
Okay. Then I would also like to say that TIO, I distinctly remember that they represented that they have a property interest, and that is because of their sublease. And I can't prove it to you because I don't have the transcript.
They may
but-
have argued that, but I base my reasons on admission, and I put the reasons in the minute order.
Okay.
So regardless of what people argued, these were my reasons.
Okay. I also need to note that Ms. Chino advocated on behalf of the state at this point and the TMT. And,
She advocated on behalf of the TMT?
well, yeah, no, she's advocating for the state. But this brings our question again forward that I want to mark on the record, that this creates a problem for Ms. China to remain neutral regarding this case.
Okay, this is a very good example. I had no knowledge she was even in Hilo. I wasn't. I didn't know anything about the ruling
Yeah.
until she's briefing me this morning that there was something, and I didn't see Mr. Sinkin's filing because it hasn't been uploaded yet. But right now, all we're doing is wasting time.
Okay, well, I just want to just state for the record that we need the AG's office to be neutral in our case, and I do object to moving on to the cross-examine because he's going to be putting on the record lots of different things, and we're not even sure if they're a party or a proper party or whatever.
Wait, who's going to be putting on the record?
TIO's witnesses. We're going to be forced to cross-examine all these witnesses, and we don't even know what's happening. So,
Well, you do know what's happening because I have been very clear this morning. We are moving forward on the CDUA application.
okay,
Wait, I'm going to ask security to make sure that, because it's distracting to me, there's some noise coming from the gallery. So if there's a problem, or I see it's coming from the floor, so I'm going to ask, please, can we be, you know what the procedure is. If you need to say something, please come to the microphone, but otherwise, it's difficult for us to keep the record straight and me to stay focused. So, Ms. Peixoto, are you done?
I just have one last thing.
Sure.
They're, for the record, they are really not on the application. So this is a hearing about that application. And
Yes.
so,
That's right.
that's where some of the problem lies. And then just
Ma'am,
for,
excuse me.
yeah.
The only one on the application is the university, right?
Well, actually, I believe it's a university on behalf of the TMT corporation, which is different, according to Mr. Ng, from TIO. So,
The UH is the applicant, right?
Yes.
You're
on-
telling me TIO was not on the application, right?
Yeah,
Okay, so whatever may have happened, I don't know if it involves TIO, TMT, whoever, I have to look at it.
okay.
But right now, we have the UH application. This is what we are focused on. This is what the hearing is for. And
Okay.
everybody has a chance to put on witnesses, whether you're the applicant or a party.
Okay.
That's the process.
Okay. And my last thing is just I wanted to note for the record that I'm not fundraising for any, I'm not fundraising for any protectors to come to Hawaii. I just want to state that on the record because I was very misquoted in the newspaper. And I just want to be clear that I'm not fundraising. And I don't know about a $250,000 fund to bring people from the mainland to Hawaii, okay? So I just want to make that on the record. So you understand also, it's been problematic for me the last couple days.
I have no idea what that's
I know
about.
because you're not reading, you want to stay out of reading the newspaper,
Well, I
but
have a lot to read.
yeah.
Thank you, everybody.
Anyways, mahalo.
All right,
Thank you.
sure. Thank you for your comments. Mr. Fergestrom?
I did submit it this morning, a motion to remove TIO, TMT or TIO as a party for lack of standing, including all submissions into the evidentiary library,
Okay,
along
thank
with
you.
a memorandum of support, which basically talks about their, your utilizing your discretion to allow them in on the special conditions, being that they had a financial interest. Thank you.
What special conditions? I don't think that I put that in the order.
You
I didn't
did.
condition anybody's admission as a party
You
on,
actually did because they don't have a unique standing?
so I conditioned your admission as
No.
a party?
No, you conditioned theirs. You gave them a special discretionary interest to be a party to this case.
Okay, I'll have to check that again,
Thank
but
you.
that's not my recollection.
Thank you.
Thank you, Mr. Fergestrom. Mr. Sinkin?
Just to be clear, Your Honor, I did serve everybody with an order last night. I mean, with a motion, not an order, I wish. With a motion last night and delivered it this morning to Mr. Kane.
Okay, great.
And I understand that, we have this process of uploading, but I think we also need to be aware that there may be circumstances that arise that call for a more immediate attention than the uploading process allows. Here we are on the verge of calling all these TIO witnesses when a question has been raised as to whether TIO is appropriately in this proceeding as a party. And you're saying go forward. I'm suggesting maybe a stay is in order to figure out exactly what the status of
Mr.
TIO
Sinkin,
is.
I mean, really think about this.
Okay.
You want me to stay the entire proceeding based on an oral ruling from the circuit court. I haven't seen a written order, which is what I have to rely on, and you do too as a lawyer.
Right.
And I haven't seen the legal briefing. All I know is what's already occurred. I don't have a basis to stay. I can't do that, and I'm not going to do that.
Okay.
All
Thank you.
right. Thank you, Mr. Sinkin. Mr. Sanderson, unless you want me to change my mind, I don't think you should spend a lot of time on this.
Very briefly, I simply note for the record that the TIO and the university have two contractual relationships. One is a sublease, and the other is a scientific cooperation agreement. Thank you.
Thank you. Yes, Mr. Ching, anything new?
Mr. Ching, yes, I believe so. I'd like to note for the record, at least, that Ms. China, who is your attorney advisor, I believe,
Yes.
was present in court yesterday, and she represented BLNR, and Suzanne Case. And if you should be willing to take some kind of judicial notice, you could get first-hand information from her. Thank you.
I'm not sure what that is. Mr. Freitas? Good morning.
Good morning, William Freitas present. Sorry I was late.
It's
My
okay.
wife and
I noted
both
your
present.
appearance at 9:20.
For the record, I'd like to express that I'm really disappointed in the way the media has been reporting about us as protectors of the Mauna. fundraising for people. And I just wanted to make note of that because somehow the way the media gets information is coming from here, and I don't know how.
I promise it's not me.
Okay.
Well, I didn't know anything until Ms. Bichotta.
By misleading the public, it has caused a lot of remarks and makes us look like we're some kind of something that is based on money, and that's not what we're here about. We assure you that everything I'm here doing is out of my own pocket. So, based on those things, I think whoever is reporting, misleading the media, for them to advertise things, to report things on the news like that, I really am disappointed with that. And it puts me more under threat, duress, and coercion in this proceedings. So, and another thing I would like to say is if we're just relating to the permit, I stand with their comments on how this shouldn't be allowed, but I respect your decision. Aloha.
Thank you, Mr. Freitas. Okay, so until Ms. Bichotta said something this morning, I was not aware of whatever other story is going on outside of this hearing. With regard to the media, from the very beginning, we have followed the Supreme Court's media rule, and that is a pooling situation so that the media can be present if they wish to, take pictures through the Tribune Herald. They share the filming with Naleo because that's the pool situation. But the reason, I want to talk about the underlying reason that we have a policy with regard to the media, and that is that they do a service to the community to inform them in the best way they can about things that are important to our community, such as this hearing and everyone's positions. I think it's difficult, unless you're sitting where I am and I get to see everything every day, all the evidence. It's difficult to always get exact context, exact picture, but they do the best they can. And I don't know about this other story. I know that there have been many stories. I don't know about accuracy. I do believe that everyone tries to be accurate. But I have first of all, a belief that the media is necessary so that our community knows what's going on. And that's built into our Constitution by way of the free press. And it's built into our culture that all of us look at the news or the newspaper or the magazines or whatever to learn about things that are important to all of us as a community. So I'm sorry that that's going on. I think that the more open we can be by having this televised, and also, but I don't know about the outside things. This sounds like an outside thing to me, and that's certainly not been discussed here in our hearing. So I can only speak to you about that. Yeah. Okay, so having said that, once we get a written order, I imagine there will be a motion or perhaps an amended motion to include the order. I would like to look at the briefings. If we have to stop the hearing, we will stop the hearing if that's what the law requires. But right now, I think the law requires that we keep going because we have an application. We have the hearing, contested case hearing on that application, and we are proceeding unless we have a legal reason to stop. Okay, so Professor Callies, I know you've been waiting patiently. If I could ask you to please take the witness stand. And Mr. Shinyama, I would like an offer of proof. And have you given Professor Callies a copy of his statement?
Yes, he has one, Your Honor.
All right, excellent.